Yes, good afternoon. Thank you, everyone. You may be seated. I am Circuit Judge Brant Ford Winston Worth. I'm joined this afternoon by Associate Justice Willow Clarkson and Magistrate Reginald Blackstone, sitting by designation. And we form the appellate panel on this matter 2025 AC 011, Sparrow Winters versus the State of San Andreas. Before we begin, I will ask counsel for the appellant to identify themselves for the record.
Kathleen Montoya for the Public Defender's Office, acting as counsel for the appellant, Your Honor.
Thank you, Mrs. Montoya. Counsel for the appellee, please do the same.
Honor from the Department of Justice.
Say that one more time, Mr. McKnight. I think the recorder didn't pick you up.
Bert McKnight from the Department of Justice.
Thank you very much. As a reminder, we are present in court today to consider an appeal of the sentencing of Sparrow Winters to be executed by the state. I will now inform everyone of this court's rules. To begin, both parties are expected to maintain a high degree of professionalism. I hasten to remind the parties only to address this court and not each other. Everyone present for this proceeding will maintain respectful behavior and abide by courtroom etiquette. Those attending will respect the authority of this court and will comply with this court's instructions. All electronic devices must be turned off or set to silent mode. No recording or photography is permitted by those in the gallery other than approved news media. Conversations shall be kept to a minimum and conducted in a whisper so as not to disrupt this proceeding. If you need to take a phone call, do so outside of the courtroom. For appellate arguments, each party will be afforded 30 minutes of argument. Unlike trial court proceedings, the panel can and will interrupt the parties during argument to ask questions. The appellant may reserve up to 5 minutes for reply argument, but they are expected to keep their own time. Given the gravity of the proceedings before the court, the panel can and will ask the parties for additional argument at our discretion if we deem it necessary. With the rules established, I understand there are some pre-hearing matters to address. I would first like to discuss the attempted evidentiary filing by the appellant. Mrs. Montoya, would you kindly explain your posting?
Yes, Your Honor. The nature of the posting is a psychological assessment carried out by Dr. Calicom for the appellant, and this was performed on the 25th of February, and this will detail in more firmer terms what was argued by Dr. Cassidy-Wren during the sentencing hearing in more firmer words and affirm the medical grounds by which we are making this appeal.
All right. Now, just to clarify, Mrs. Montoya, this is evidence that was not available at the sentencing hearing. Is that right?
That is correct, Your Honor. As I said, this evaluation was not able to be carried out until the 25th, which would have been 4 days after the sentencing.
Was this due to Dr. Calicom's availability?
I'm not sure at this time, Your Honor. Dr. Calicom is not someone that is typically able to be reached through emails.
Yeah, no, I understand. Just wanted to make sure that was the case. All right. I'll let the state provide any argument about whether or not this should be considered.
First off, where was this?
It hasn't been submitted yet, Mr. McKnight. Okay, it would be shared today, and then we could take a recess for you to review it. I suspect it's going to be similar information and that it would not substantially change your arguments for what it's worth. But it was not admitted because new evidence is not typically considered on appeal. So we wanted to wait to address it until we were all present in court here today.
Yeah, the state would agree with Your Honor, of course, on that nature, that new evidence isn't typically accepted for an appeal. Again, yeah, that doesn't really change most of my arguments. And we already have a prior examination that we could always look at, which is the one that was provided during sentencing. So I don't think that the state does not feel that a second review is needed, or really warranted.
What's your argument against us considering it, Mr. McKnight? Because from my perspective, it would not be prejudicial to have everyone be able to look at it prior to argument and afford reasonable time. We could take 10 or 15 minutes. How long is the evaluation, Mrs. Montoya?
The evaluation is it is 3 pages. However, only 1 page is of significant length. The other two are, about half a page each.
Mr. McKnight?
Yeah, the state would be curious as to when the evaluation took place as well.
She said the 25th, Mr. McKnight. So it was after the sentencing hearing. And as I just asked, it sounds like it was due to Dr. Calicom's availability.
Gotcha. I mean, of course, the state. I guess there really isn't much of an argument for just allowing it to be viewed.
Yeah.
Well,
however, let's just do that really quickly, and then we'll
Okay.
figure out where to go from there. Mrs. Montoya, would you please, in a sealed email, produce the statement to the panel and to Mr. McKnight?
Yes, Your Honor, that has been submitted in a sealed email.
Oh, that was very fast. You were ready to go. I appreciate that. Confirming receipt of the same, and I agree that it's really the middle page that is the one that only has a substantial amount of text on it. Let's have a quick look at this. There is a specific finding here, Mr. McKnight, that I think will be relevant to your argument, although it may not affect the arguments that you're making. So how much time would you like to review this? I don't think we're going to need that much time from the panel's perspective.
Just give me like 2 minutes, please.
Yeah, of course. We won't even recess. Actually, no, we will. We'll do a 3-minute recess. Court's in recess. Court is now back in session. Mr. McKnight, you had enough time?
Oh, yes, Your Honor.
All right, wonderful, wonderful. Mrs. Montoya, is there anything else pending? Actually, yeah, you're the appellant. Sorry, I always get mixed up whenever we have these appeals where the appellant is the defense from the trial below. Excuse me, Mrs. Montoya. Is there anything else pending prior to the hearing?
The appellant would submit the statement provided by Dr. Cassidy Wren again during the sentencing hearing.
Required. The entire underlying record is considered by the panel.
Fantastic. Then in that case, there is nothing further at this time, Your Honor. We are ready to begin with the appellant arguments whenever the state is prepared.
All right, and just for the benefit of both parties, for all future appellate proceedings, you don't need to introduce evidence, just reference it from the record below. As long as it's been submitted there, you're good to go. If there is something that has arisen after the underlying matter has been addressed, you should indicate that on the docket in the way that Mrs. Montoya did here. Although I will admonish Mrs. Montoya to make it clear in the future, although I think she understands. All right, Mr. McKnight, you got anything prior to argument?
Nothing further, Your Honor. The motion I put on the docket, you can moot.
Was that regarding timing?
Yeah.
Oh yeah. For future reference, if we've set a date, especially the day before, we would not move that date. It was very, very difficult to schedule this hearing, and so we'll just, it's likely that once a date's been scheduled, it will probably be kept unless there are extreme circumstances. But we appreciate your consideration, Mr. McKnight. All right. With that out of the way, Mrs. Montoya, you're welcome to stay at the desk. I realize that the setup here is a little bit different than occupation, but we thought that this would be a better venue given the circumstances. However, you can also, stand in the middle if you wish. Just whatever you want to do. Whenever you're ready, as soon as you start speaking, we'll start the timer.
All right. Thank you very much, Your Honors. I appreciate the court's time in this matter. So, as the initial filing suggested or argued, the issues at play here is that the death sentence carried out by the trial court on the 21st of February 2025 is
Mrs. Montoya, just to be clear, the sentence has not yet been carried out. As I understand, Mrs. Winters is sitting here. Thank you.
Was carried down on the 21st of February. We believe this to be in direct contradiction of HR 272, the Psychiatric Hold Act. So the specific section of the Psychiatric Hold Act that this is going to be a violation of is going to be towards the very bottom. This is going to be Section 9, Fitness to Stand Trial. We believe that there is significant grounds to reason that the accused is someone who is not of sound mind and is not fit to be executed and is of limited competence, legally speaking. At this time, there is significant medical evidence to support this claim. It would be a violation of the legislation put forth, and it would be a violation of the client's rights to allow this individual to be executed. It is important for the appellate to differentiate the fitness to stand trial statute from the fitness to be executed. At the time of trial, the appellant was deemed fit to stand trial and that she understood what was happening at the time. That does not make her fit to be executed. The diagnosis states that Ms. Winters was facing significant mental health issues.
Sorry, counsel. I'd like to just interject here on
course.
one point. Primarily, your filing makes great reference to HR 272. However, I'm not sure if you've made any reference or if you plan to make such reference to HR 138, the Capital Appeal Act 2000. Which year is that? Oh God, it's a bit of an old one. There is no year on it, but it's 2022.
2022.
Yes, indeed. Thank you very much. Yes, you make no reference to that. Would you be able to make such reference to it now, or is this something that's going to be coming up later? Do we have to? Is that something that's up and coming, so to say?
I'm happy to address it now, Your Honor.
Outstanding.
So obviously the Capital Appeal Act is the grounds in which we are filing this appeal. We filed the appeal within the 7-day window that's required under Section 4 of HR 138. Obviously, this has been joined, and the condemned has a right to have the appeal heard. We understand that it is only a single sitting judge that needs to take issue and find reason to overturn the sentence of death. And we believe that there is significant grounds to allow this to take place. So we have considered the Capital Appeal Act, and as mentioned, that is the specific grounds in which we are filing this appeal.
Understood. Something that I would like to highlight here is there are two main definitions with unfit in these proceedings. Primarily, Section 9 provides, unfortunately, two definitions for fitness to stand, so to say. The first one being in the first paragraph, whereby it is surrounding the apologies, one moment. The actual the nature
Fitness to stand
and
trial.
consequences of the proceedings. The subsequent one, however, is mostly forgive me, apologies, I'm all over the place.
The second one is about fitness to be executed, essentially, Mrs.
Yes.
Montoya.
In essence.
And could you please explain, from your perspective, how the court should distinguish these and on what basis?
Fitness to stand trial versus fitness to be executed?
Yes. It says no defendant may be put to death if they are unfit to be executed. They're unfit to be executed due to mental illness. They are rendered legally incompetent and or not of sound mind. How should we distinguish this from fitness to stand trial? Why should we not find that Miss Winters is fit to be executed on the basis that her counsel admitted at trial that she was fit to stand trial?
Indeed, Your Honor. It was, I believe, Dr. Cassidy Wren who cleared her from psychiatric hold for fit to stand trial. We would assert that fit to stand trial would be someone who is able to comprehend the situation that they are presently in and the charges that they are facing. Ms. Winters does not have the capacity to understand the reasoning why it has been given. Indeed, there are hallucinations, delusions that have affected her ability to reason at the time of the charges that were, at the time of the crimes that she's been charged and sentenced for. So we would assert that there is a clear difference here, that you can be fit to stand trial if you understand the charges that you're currently facing. However, the fitness to be executed, if someone committed these acts as a result of criminal insanity, for example, that would make them unfit to be executed. And we believe that there is significant evidence in both evaluation letters, well, evaluation letter and the statement given, to support that claim.
And how does the statute support this distinction? Can you help me understand?
Yeah, absolutely. So if we are referring to the statute being HR 272,
That's the one.
yeah, fantastic. So if the individual could not understand the nature and the consequences of the proceeding, that would make them unfit to stand trial. It was determined that Ms. Winters understood the nature of the charges that she was facing, as well as the potential consequences she was facing. I am confident that you can assume that we being the defendant counsel at the time, made every effort to make the client aware of the potential consequences during all negotiations and proceedings, and it was affirmed that the client did understand those potential consequences at the time. So if you're asking for how they're
And how does that differ?
it differs in the having a mental illness that affected directly someone's ability to reason and their ability to control their actions contradicts the idea that they would be executed in order to be held accountable for those actions. If someone committed these crimes and was charged with these crimes as a result of significant mental health issues that were impacting their ability to reason and indeed impacting their actions themselves, that would affect their criminal liability for these charges and the mens rea to these charges.
Well, I want to be clear that the appeal before the court today is not about whether the finding by the trial court with regards to guilt or innocence was correct. The appeal today is about whether or not the sentence is correct. Is
Correct,
that
Your Honor.
right? That's how you file it. Okay, all right.
Yes, Your Honor.
So given that the charges themselves, the findings of guilt and innocence, or at least guilty not guilty, are standing, help me understand why the court should not find that Ms. Winters, troubled though she may have been at the time of the offenses, she was able to stand trial, and she's here today, and she's, as I understand, has participated throughout the process. I've seen that she's even posted on the docket a few times. Help me understand why she's unfit to be executed as a result.
Well, as a result, Your Honor, there are direct medical findings here that have been submitted by Dr. Calicom that find Ms. Winters unfit. Once again, she is able to comprehend the sentence, but not the reason why it's actually been given.
Does the statute say anything about comprehending the reasoning for a sentence?
The comprehension for reasoning of a sentence would go into direct line of someone being rendered how legally competent they are, or of sound mind, the soundness of their mind. And it's clear that this is still an ongoing impact that is affecting Ms. Winters, and it would be improper to execute her instead of submitting an alternate sentence.
I just find it interesting that Dr. Calicom does say that she's unfit to be executed, but does not go into detail as much about whether she is of sound mind, given I assume that this report was written, in support of the appeal, or at least that, that was the goal. But we have discussion of motivation, and we have discussion of mental state, but whether she is of sound mind, she does have some diagnoses in here, some discussion of symptoms, but part of what is before the court today is the determination of what it means to be of sound mind. That's likely going to have to be at least a small part of our finding. Help me understand, based on the letter from Dr. Calicom, the assessment, as well as from Dr. Cassidy Wren, what is the distinction? Because she's sitting here, she's being compliant, she's participated in the proceedings. Why is she not of sound enough mind to be executed for her crimes?
Simply put, Your Honor, when we are considering this matter, it has to be emphasized that the explanation for these actions indicate that she was at least not of sound mind at the time that these actions were taken, and indeed continues to not be of sound mind and of limited competence. The evaluation itself by Dr. Calicom, although obviously I'm not going to divulge the specifics of it, provides direct indication as to what the ongoing struggles, and you mentioned trouble as she may be, those troubles are directly affecting her ability to comprehend the ongoing reasons for the execution.
All right, let me ask this question another way. Do you think that the legislature intended for the bar to be fit to stand trial to be lower than the bar to execution?
I believe that there were two different standards there, Your Honor. I believe that there is a distinction between a fitness to stand trial and a fitness to be put to death.
That's all well and good. That's not exactly
why would they
what
not
he
be the
asked,
same threshold? Yeah. They're defined differently, but why would we not consider them to be approximately the same? Can you help me? Can you point to anything in the statute that is indicative of legislative intent to differ and how it should differ?
Yeah, absolutely. So in the initial filing, it mentions that a defendant wouldn't be fit to stand trial if they presently suffer from mental illness that renders them incompetent to the extent they cannot understand the nature and consequences of the proceeding against them. This, I believe, to be a bar that we make when we are doing things like arraigning someone, when we are observing whether someone is able to have the
I understand the
wherewithal.
procedural posture. I want to understand the substantive difference.
Absolutely. And the substantive difference to the appellant would be that we can have someone understand why they are facing the crimes that they're facing. But the different barrier here being someone can only be put to death or a sentence can only be carried out in direct cognizance with the understanding of what they have actually. It's difficult to put this into
Well,
simple layman's terms.
let me ask it another way. Do you think that the legislature intended two different definitions of incompetent here in the statute? Is this just a drafting error on their part?
Well, the statute is 2 years old at this point, and obviously there are several different interactions between different bills when it comes into this legislation. I believe
but they use the word incompetent in both definitions here, right? It says they're unfit to stand trial, that renders them incompetent to the extent that they're unable to, And then the second one says can't be put to death. They're unfit to be executed if they're rendered legally incompetent. So they do use the word incompetent here twice, and I want your argument as to why it means different things in each spot.
Well, they've used the word competent twice. They've also used and or not of sound mind. And I believe that there is a direct distinction by adding that clause that indicates that there is a different barrier that can be met here than just the fitness to stand trial statute, as that clause specifically mentions that they have to be incompetent to the extent that they are unable to understand the nature and consequences, whereas no defendant may be put to death if they're unfit to be executed, and they would be unfit due to mental illness, they are rendered legally incompetent and or not of sound mind.
Got it.
Those are two
All
definitions.
right. That does help. Thank you very much, Ms. Montoya.
All right. Would you like me to proceed with the remainder of the brief?
Yeah, if we're not asking you questions, you can just keep on going with whatever it is you had planned.
Wonderful. Thank you very much, Your Honor. So, the professional medical opinion given by Dr. Cassidy Wren describes how Ms. Winters was diagnosed with schizophrenia and has suffered the aforementioned delusions, hallucinations, and disorganized thinking patterns. These can explain the actions for which she was found guilty, actions which she was deluded into believing were required to believe that they were necessary to appease a non-existent God, which again shows that there was an absence of control on the appellant's actions. Dr. Cassidy Wren also explained how Ms. Winters' judgment and their impulse control, as well as their perception of reality, were profoundly impaired by the hallucinations, paranoid delusions, and the disorganized thinking which she faces, which indicates that at the time of the offences, she would not have been thinking rationally, nor could she be reasonably expected to control her actions. And there are symptoms that she has continued to face, which directly indicate that she is not someone who is fit to be considered of sound mind enough to consider the consequences of her actions and the reasons why a sentence of death is being carried upon her, or imposed upon her, I should say. So we believe that there are two of those different burdens, and we believe that the burden of not of sound mind is a sufficient clause for which Ms. Winters meets that of being not of sound mind in order to make a stay to execution. Furthermore, there is
All right,
direct...
Mrs. Montoya, I do have another question. Sorry.
Yep, of course.
Is there anything in the statute or anything in legislation that we can look to generally that defines what it means to be of sound mind? How should the court contemplate what it means to be of sound mind?
So there are legal statutes of sound mind. I will quickly review if there were anything in our statutes themselves. To my knowledge, there may not be, but I will consult my findings. I was going off of the medical definitions that were found. Give me a second. So there's nothing in the general laws and definitions here. So we would assert that we would be going off of the medical definitions, the medical diagnoses given by Dr. Calicom and Dr. Cassidy-Wren. And we believe that this appeal would mark a significant point in our state's judicial history in defining what that burden could be when we are interpreting the legislation that's been put forth.
All right, so it's your position today that there is no definition existing in the statute. Is that right?
To my knowledge, there is not an existing
Sure.
definition.
All right, thank you.
And that would
You can
be
keep going.
specifically 272. Thank you very much. So further to this, the evaluation letter describes how there is a recommendation for treatment history. There is a recommendation for a treatment plan, and there are specific concerns surrounding the current housing in which Ms. Winters is kept in, that it would be deemed insufficient for an inmate of her particular challenges. And we believe that it would be justifiable and moral to have her admitted into the appropriate psychological units, that being the maximum security wing of the Harper Unit of Clinical Psychiatry at Mount Zona, which would be more than adequate to take care of Ms. Winters' needs and also ensure that there is a potential path of recovery for her. This is not an attempt to ignore the culpability, or at least the finding of guilt that the courts have faced. It is not an attempt to shrug off the severity of Ms. Winters' actions. It is not an attempt to get out of jail free card. The appellant understands that this is likely to be a permanent passing down. This is not going to result in a vacation of charges and a not guilty and everyone walks free, and nor should it. This is simply about making sure that individuals with mental health conditions are being treated appropriately, are being held to the correct standards, and are not being handed down punishments that they cannot reasonably understand nor be held liable for the sentencing of.
All right, what if Miss Winters reoffends?
If Miss Winters reoffends, that would not give her grounds to be sentenced per se. She would be held in, again, a maximum security unit. There are many people within such units who have a significant possibility of reoffending. If she commits further offenses while she is an inpatient at the maximum security unit, that would be considered a result of the condition in which she was being treated for. If a cancer patient went into remission and then was re-diagnosed, we wouldn't hold the person accountable. It is a case that this would be a direct consequence of her illness and the way in which the symptoms have manifested and affected her actions.
All right. So at what point would she qualify for the death penalty?
There is a potentiality that should Ms. Winters at a future point be found to be of sound mind, that if the courts deemed it fit and proper to resentence, it would have to be after a period of significant recovery. It would have to be a point in which the doctors, the psychiatrists specifically believe that Ms. Winters has recovered from the current psychological statuses in which she is currently suffering. However, there are moral questions as to whether it would be deemed fit and proper to allow someone to recover from a diagnosis of mental health in a maximum security unit, only to then be sentenced to execution. It may well be the case that Ms. Winters spends the rest of her life at a Harper unit. This would not be a instance in which we say, well, Ms. Winters appears to have recovered from her psychological impairments, and therefore we release her into the public. Not at all. If there is such time as which she could be deemed to be fit to face the consequences of her actions, that would be a finding for a future court. However, again, there are moral questions around the release of someone into the custody simply for execution from a mental facility. Many of the individuals that stay at Harper in the maximum security wing stay there for the duration of their lives.
Thank you, Mrs. Montoya. It's helpful context.
Absolutely, Your Honor. I am happy to provide any further context that Your Honors require. I would like to inquire as to my time.
You've got 5:44, 43, 42. Do you want to reserve
Understood.
those 5 minutes?
Yes, Your Honor.
All right, very good. We'll keep you the whole 5 minutes for your rebuttal. Mr. McKnight, you about ready?
Yes, Your Honors.
All right, whenever you're ready, you can start speaking.
So the state doesn't plan on rehashing its brief today in its entirety. We feel that the brief that we provided stands very strongly on its own with the arguments that we provided. However, I'm gonna start by addressing some of the arguments that the appellant made just moments ago. So first, looking at the medical examinations. When looking at Dr. Calico's, we'll start with the points that
Let's be careful about what we say here, by the way, Mr. McKnight.
Oh,
given the medical privacy.
Okay. So
I think you can make the points just without saying specific things, if that makes sense.
Okay.
Feel free to direct our attention to a specific part of the page, for example.
We'll start with page 2. Looking at
Yep.
the current psych status and the risk assessment. So we would
Yep.
would point the court's attention to the risk assessment, what all that says. I mean, that's not really medical information. Would you mind if I read some of that?
No, that's fine. You can read that.
Okay, so it states here that if kept in general population at Bolingbrook State Penitentiary, there is a risk to staff and inmates, and also to Miss Winters herself. My recommendation speaks on this matter. So looking at that alone is an outlier to us in this report, and is a real highlight, because this is what the state argued during sentencing as well, is that there is a substantial risk to the inmates, the staff, and even after this examination, medical staff still believes that there is that risk, which is what our fear is that there would be a continuation of harm to others that are innocent to Miss Sparrow's motives, and as the counsel across from me was previously stating, oh well, we could put her in the Harper unit, and then when she's fit, put her back in the general. Oh, and if she reoffends, then back she goes into maximum security. So really, it really comes down to, well, where does that cycle end? I mean, so she gets out, stabs somebody, goes back in. Oh,
Mr. McKnight, I'm going to
done...
interrupt you here. I think part of the point that Mrs. Montoya was making is that Ms. Winters would not be released to the general public. A commutation of her execution is not a commutation of her sentence overall. In fact, if we were to commute the execution, we would reverse and remand for revised sentencing consistent with our findings.
My apologies, I must have misunderstood.
Yeah, that's okay. I mean, you're certainly welcome to make arguments about whether and how she should be sentenced and to what circumstances
Sure.
at the appropriate time. But just for everyone's benefit, because this was not an appeal of the sentence, it was an appeal of the execution. Sentencing is out of scope for today's considerations.
I see. And then looking at the first sentence of the recommendation, so I'm going to read that first sentence if you don't mind as well.
Sure.
The first sentence of the recommendation states, given the evaluation for fitness to be executed, I find Miss Winters unfit. Now, I find the wording of this to be quite choice, as it doesn't say unfit for what? Unfit for trial? Unfit to be executed? Unfit
Well, it says unfitness for execution. I mean, come on, Mr. McKnight.
Actually, this raises a fair point. Mr. McKnight, we posed this question to the appellant, and I see no reason why we shouldn't pose it to you now. In light of you highlighting this slight ambiguity in the psychological evaluation, we shall turn to the two definitions in Section 9 once again. I trust you have more than likely considered these definitions as they have been raised to the appellant. What are your thoughts on these two definitions? Are they mutually exclusive, or are they, as may very well be the case, a legislative error?
Are you talking about the...
So these are found in Section 9 of HR 272, the Psychiatric Holds Act 2023. In
the first two paragraphs.
Yes, indeed. And then after the final paragraph as well.
But are we talking about the definition for unfit to stand trial or unfit to be executed?
Well, there's two definitions, Mr. McKnight. That's what we're trying to reconcile today.
Hold on a second here.
It's what we spent a good chunk of our time questioning Mrs. Montoya about.
No, I understand. There was... sorry, you said it was which part?
Well, there's two. So it's Section 9, and then there's two definitions.
Yeah. Okay. Yes. So we're talking about incompetent and not sound mind, right?
Well, there's two definitions. So there's fitness to stand trial, and there's fitness to be executed. And the legislature deemed it appropriate to establish different definitions and standards for each of those two items. And the questions that we asked Mrs. Montoya were about whether they were fundamentally the same or not. And so now we have the same question for you.
I apologize. Yes, I would say that they would be generally the same, as it says no definitive.
Then why are they different on the statute? the version of this that Mrs. Montoya had to answer was, of course, why do they use the same wording if they're meant to be different? But the version of it that you have to answer is, why are they different if they're supposed to be the same? You see, you both have some difficulties here, and we heard hers, and now we want to hear yours.
If you'd like, I could read out the two separate definitions in more like plain terms.
Give me a moment.
So just for your assistance, Councillor McKnight, it's the first two paragraphs form one part of the definitions for fitness to stand trial, and it is the final paragraph which pertains to execution. It's just directly above the whereas parts.
Yeah, it'll be the second sentence in that last paragraph.
I mean, I'll be honest with you. I still believe that these are supposed to be the same, as it says, no defendant may be put to death if they're unfit to be executed. So they kind of go hand in hand. Now, why they're separated
there's
differently?
differences
I
in
really
the
don't know.
wording. There's differences in the wording, Mr. McKnight. Can you see that?
Yeah, the plainly the first one without everything else. Just a defendant is unfit to stand trial when they presently suffer from a mental illness. So presently being they are not understanding the charges that are being pushed against them in the present. They're not understanding the present, like that they are in a courtroom, that they are communicating on their legal matters, etc. And then the second part at the end there, it says a defendant is unfit to be executed if due to a mental illness they are rendered legally incompetent or not sound of mind.
I see. So one's like a before and one's like an after. Okay.
Yeah, they're two separate procedural postures, Mr. McKnight, and then they're also, Mrs. Montoya is arguing they're separate standards, and we're willing to hear your argument about how they're not, but it is, persuasive, and canons of construction for statutory interpretation. We don't have the occasion to talk about them very often in this state, but if I'm writing you an explanation and I say something two separate times in two different ways, I probably intended for the two things to be different in some capacity. That's how we usually read statutes as a judiciary. But if you want us to find otherwise, we're here to hear you out.
Well, I mean, starting with the fitness to stand trial, because I mean that is the basics. That is the basis for part of.
Yeah, we understand that they did deem her fit to stand trial, both the court and her counsel.
Correct.
So that part we take under advisement. Explain to us how the fitness to be executed is not different.
Well, I apologize. I suppose it is actually different.
All right.
That was misunderstanding.
Got it. All right. Well, given that that's been admitted, can you explain to us why she is fit to be executed? Given the statute's definition.
Well, you guys made your honors. You all made some of the points that I was going to bring up, which is the fact that, she's been attentive to these court proceedings. The appellant made claims that the appellant made claims that she doesn't understand, that the defendant doesn't understand what's happening or doesn't understand the sentence, but we can clearly see that there is a lot of understanding from the defendant. Even in these psych evaluations, there's understanding all throughout. It's not like she doesn't can't process what's happening. She can process what's happening. And while clearly Miss Winters does have some sort of mental health issue here, being deemed legally incompetent or legally not of sound mind is a completely different standard from just somebody having a
So
mental
so
health
what should
issue.
that standard be, Mr. McKnight? Because we asked Mrs. Montoya this question, and I want to hear your answer as well.
I mean, really, it's up to you, you to determine.
Yeah,
that.
but you're here to sell us. So what should the standard be? Under what standard would we find in your favor today? A definition of sound mind is basically what I'm asking for, just to be clear.
Well, to be of sound mind would be, somebody who demonstrates that, they have some sort of normalcy to them. It may not be somebody who always is having a mental health issue or something like that, but I would say that somebody of sound mind would display factors that are consistent with normal, quote unquote, normal people that you would see in the world and coming to court and things like that. Somebody that goes to therapy and completes it,
Well, I mean, I
participates
go
in
to
success-
therapy, and
Well,
I
yeah.
would say that I'm of sound mind, but I
Right.
also know that there are people who go to therapy and are not of sound mind, and they might go throughout the world, but be incredibly troubled and perhaps not even understand the circumstances that they're in. So I'm asking, how do I articulate a legal standard? If you're going to write my opinion for me, what would you want it to say to determine that someone is of sound mind or not of sound mind? Because the legislature, in my opinion, clearly intended that certain individuals be accepted from the death penalty based on their mental circumstances. And our job, as it always is on these appeals, is to draw a line. So where should the line be drawn?
I think the line should be drawn somewhere in between somebody who was displaying previously, and then obviously more currently, extreme mental health issues to where they are clearly showing
Only
a lack
extreme
of
mental health issues?
Yes, I would say extreme mental health issues.
All right, and what qualifies as extreme?
I would say somebody who is, actively hearing and reporting, voices, actively acting in a manner that is irrational and violent.
Well, we have two statements from two different doctors who say that Miss Winters is actively hearing voices and experiencing delusions. Why does that not meet the standard that you just articulated?
Well, I'm talking about, those voices, then acting upon those as well. Like clearly, before she was hearing
Isn't that what got her here today?
Well, yes, and so she was hearing the voices previously and committing crimes, and then now.
So now, because she's being treated, she's fit to be sentenced to death? The legislature clearly intended something here, Mr. McKnight. I'm trying to figure out what it is they intended, and I'm trying to take you seriously. I want to follow your logic, but I need to draw the line.
I have no idea what the legislation intended. I'm gonna be honest with you.
Well, I don't either. They weren't terribly clear about it, but we have to pick something, right?
So we've established that your view is that these definitions are different. The main thing here is, how are they different? What is the intention behind this difference? We're not expecting you to be a clairvoyant here to be able to immediately obtain such an intention, of course. But if you were to, say, imputate an intention or infer an intention from this distinction, what would that be?
We're imagining that there are different thresholds here, is basically the point. And we want to know what those thresholds are. Perhaps we could use an example. So let's say we did have, someone who is previously violent. Is it the case that all previously violent... Mr. Gilgully, I hope you're not going to try to speak to Mr. McKnight unless there's a matter of court security that we need to all be made aware of. All right, very good. If you just want to sit in the front row, that's fine. Sorry, I got concerned for a second. Sorry, Mr. McKnight. So we have someone who is, let's say, previously violent, just like Ms. Winters, and then they aren't violent for a while because they start getting treatment, but then they commit another violent offense, let's say. Is that person fit for execution?
I think they could be, yes.
Really?
Yes, because now
you said that it was someone who is being violent who would be unfit for execution.
No, that's not what I said.
All right. Well, why don't you restate it again, just so we can all understand?
You're when I stated that, you were talking about the extremes. When I talked about the extremes of mental illness would render them unable to be executed. So yes.
So
like
who
somebody...
else is unable to be executed? How? So you've established one end of the line, which is, or at least above the line, which is obviously the extremely violent people who are actively suffering delusions. All right. At what point does someone become fit for execution from the state's perspective, based on this definition?
Well, they might not ever become fit for trial for execution.
I mean, I'm not here to abolish the death penalty, Mr. McKnight. Just to be clear, that's not what's before the court today. The question is just who gets executed if they have mental health issues, because the statute doesn't say anyone who's seeing a therapist can't be executed. It says that they have to, not be of sound mind, and so we just want to understand at what point someone becomes not of sound mind from the state's perspective.
Well, they become not of sound mind when their mental health is so extreme that they're not even able to comprehend what's happening at all, and they display that they can't comprehend what's happening as well.
All right, and is evidence from doctors not enough to establish that, or how should it be established in your view?
Well, only one has said unfit, but it doesn't say unfit for what. And I think that's important.
Well, just to be clear, Dr. Cassidy Wren's statement says, "I do not believe it would be morally correct for Ms. Winters to face the death penalty due to the crimes she has committed solely for the fact that she was not in the right state of mind at the time she committed them." She cites a precedent that's not currently before the court today because we didn't get into the whole out-of-state precedent situation, so it's not a big deal. But she does explain that Ms. Winters was suffering delusions, and this is public, by the way, which is why I'm reading it. And that while she can change, she believes, and that's part of the reason why she opposed the death penalty for Ms. Winters, she was, in fact, having the hallucinations of the kind that you described.
Yes, but that was written as more of like an opinion for that was for during the part of sentencing for like victim impact statements and other statements. So I wouldn't really consider that to be like a medical recommendation per se. On top of that, there was never any sort of plea of insanity. I mean, there was a lot of stuff needed to be done prior to all this.
Well, plea of insanity is a culpability determination, Mr. McKnight. Again, we're only here for whether or not execution is on the table.
I think
we're not here to. Oh, go ahead.
One way we could potentially resolve this is: do you think, counsel, that the standard expected, the mental standard expected for somebody to stand trial should be higher or lower than that we consider for execution? Whilst they are different definitions, one would say that the mental faculty standard would probably be different. How should it be viewed? Should one be more mentally stable to be able to stand trial, and then afterwards less for execution? For example, if there's a deterioration, what standard should the court set?
I think that they should be the same because if you can't stand trial and you can't comprehend and that, and plus, I mean, if you can't stand trial, then you wouldn't be put to death, right? So it's kind of a
Well, but Mr. McKnight, I mean, you can understand. Mrs. Clarkson was doing a great job explaining this earlier, actually, about how someone might not be aware of their surroundings, right? And the charges against them and the consequences of those charges. That's really what's contemplated by fitness to stand trial. And of course, we've actually had a number of proceedings where a judge has done a psych eval or something of the sort and determined that someone isn't able or fit to stand trial. Either the most common one of these, I think, is when someone is under the influence, and so they have to be held until arraignment, right? I'm sure you're well aware of those circumstances. But fitness to be executed, of course, is a different threshold contemplated by the legislature, as you've described. And it has to do with, as far as I can tell, the legislature intended to contemplate the individual's faculties and the circumstances that they're experiencing, not just like who they are as a person and what they've done. It's not about the seriousness of their offenses. It's about the seriousness of their experience. And so from what someone's experiencing, we understand that you've talked about the people who are having the most extreme reactions, but we've got to draw the line somewhere in the middle is really what we're trying to get to. Somewhere in the middle. And it doesn't have to be all the way in the middle. It just has to be not at either complete end of the spectrum. We wouldn't want, awful people to walk around, but we also wouldn't want to execute someone who just doesn't understand their circumstances. And the question before the court, the reason we're all here today, is at what point in someone's psychological experience, based on what the legislature has described, is it allowable, morally, otherwise, to consider them for execution? Also, I'm so sorry, but we're going to be in brief recess. The timer will be paused as a result of Mrs. Clarkson's narcolepsy. Very good. Mr. McKnight, are you prepared to resume?
yes, Your Honor.
And Ms. Montoya, are you prepared to resume?
Yes, Your Honor.
All right, wonderful. Mr. McKnight, whenever you're ready, we'll start the timer again. You've got 6 minutes and 17 seconds.
Where do we leave off at? I apologize.
We were talking about lines and extremes and somewhere in the middle.
Yes. I don't really have anything further to add.
All right, very good. Do you have any other points that you wanted to make? Mr. McKnight?
Yeah. When it comes to sound mind, we also want to point to Dr. Cassie Wren's statement, where in the fourth paragraph, first sentence, it says, Ms. Winters has shown a desire to understand her thought process and actions through talking to Dr. Callum and myself. So we just like to emphasize that it does appear that Ms. Winters has had sound mind throughout the majority of these proceedings.
Well, hold on. Let's take a step back. Let's read that sentence again.
Sure.
What do you understand it to mean when it says that she has shown a desire to understand her thought processes and actions? Do you understand that to mean that she currently understands them?
I think it's consistent between when this was submitted back in sentencing and for whenever this assessment took place, which would be sometime before sentencing, to now.
If I had a desire for something, do I currently have that thing? Let's say I desire some ice cream. Do I have ice cream right now?
Well, no, Your Honor, you don't have ice cream right now.
Right.
But you want ice cream, and you know what ice cream is.
Certainly, and that point is well taken, Mr. McKnight. Certainly. But I want to make sure that I understand the letter and that you understand what you're arguing, which is the statement from Dr. Cassidy Wren was that she's shown a desire to understand her thought processes and actions. And I would read that personally as indicating that she does not currently understand her thought processes and actions. Does that make sense?
Yes, but however, I would still point to the fact that there is, I think there's an implied, um, there's implied some understanding, um, there as well.
Okay.
Kind of
Alright.
like with your ice cream reference, you know what ice cream is, and you know you want it, right? If somebody had no desire to understand because they don't understand at all, I think that would be phrased differently. You know,
Okay. Alright.
and I bring up the extremes because the death penalty is the most extreme punishment we have.
Certainly is.
We're ending a life, and that's why I was arguing for extreme cases of mental health would be would not be subject to the death penalty. You know, somebody who and I'm not arguing for the middle ground because there's a lot of people that have mental health issues, and so it would be difficult to determine a defined threshold of somebody who has minor anxiety to extreme anxiety, right? I wouldn't want somebody who just has minor anxiety to be exempt from the death penalty. I would want somebody who is at extreme levels of mental health to be exempt from the death penalty. And I think that there's a lot here that has
Is there any indication of what the legislature intended with regards to how extreme it would have to be?
I don't believe so, but you previously asked me for my definition. You asked me to sell it to you.
No, I
and this is
understand,
my
and
sales
I
pitch.
appreciate that. I'm just curious if you had anything to share. That's all.
I don't believe there's
Not at
anything
this time
direct.
is a fine
No.
answer,
Yeah,
Mr.
it's not at
McKnight.
this,
Don't worry
not,
about it.
Yeah, sorry, not at this time. I'm just trying to answer your questions as fully as
You're
possible.
doing great. Thank you. Thank you. I appreciate it.
And then just to close things out, you know, once again looking at the brief that the state provided, you know, we still feel that this that the brief is strong and stands on its own, and obviously that should be considered. There really isn't anything further.
I have a quick question before we finish this out. There's been some mention as in these reports as to medication, and medication possibly um, making it so that the defendant is fit to stand trial and understand proceedings. Where is your or the state's thought process on, say, if they would refuse medication and then no longer understand proceedings?
So that's it's an interesting and difficult line to draw in that regard. As if somebody's receiving treatment and they're getting better and then they relapse from that. I don't think that there's any reason to put a hard line in the sand to say, oh, you're going to the chair now, or the firing line now. So I wouldn't, the state would not advocate for that. However, if there's a relapse in medication and a continued refusal for medication and further incidences that cause a risk, then I think then there may need to be a process for some sort of hearing in regards to that. I think due process would still remain for somebody in a situation like that, unless another determination is made by the courts as far as a contingent, some sort of sentencing contingency, if you will, in that regard. However, I see the point that's being made with medication. And how she is now receiving medication. Things seem to be on the rise. However, I think looking at the totality of everything with this case, there's been a understanding. There's been some sort of understanding of what is happening from the get go. As it was pointed out that Miss Winters has asked on the docket to be in court for every proceeding. She knows how to post to the docket. She knows she wants to be here to listen to the proceedings. I think that there is more. I think based on the actions we've seen from the defendant, there's more competence here than that is being led on by medical staff. I am by no means a medical expert, but I think that from simple comprehension,
Did the state seek any evaluation or other evidence regarding what you're talking about during the underlying proceedings?
No, Your Honor.
All right, thank you.
I don't have any further questions.
Mrs. Clarkson, you got anything further?
Nothing further from me.
All right, thank you, Mr. McKnight. We've got 5 minutes for Mrs. Montoya. Mrs. Montoya, I will advise that Magistrate Blackstone has just informed me he has another engagement in about 15 minutes. So if you want to use your rebuttal, you're more than welcome to. But if you want to, well, we'll handle it amongst ourselves. Just wanted to let you know.
Yes,
Understood.
please don't feel any sort of obligation to use, as the youth would say, speed run your right for reply on my account at all. Please utilize it to the full.
Understood. Thank you very much, Your Honor. The only rebuttal that we would be using this 5 minutes for would just be to point out the distinction made by the state is perhaps improper. I wouldn't go so far as to say seeks to ever besmirch the work done by medical staff. Obviously, as stated by Councillor McKnight, none of us here, majority of us are medical experts. However, it is understandable that hallucinations and lapses in judgment and periods of clarity and the lack thereof are expected symptoms when it comes to the diagnoses that Ms. Winters had faced. And so I would caution against the concept that a moment of clarity might be considered, I see, well, this clearly is someone who is of sound mind. There are moments when patients diagnosed with Alzheimer's and dementia are able to recall specific events, but that does not mean that if a power of attorney has been given over that person for that reason, that it is then granted back to them because they can suddenly remember their mother's face, for example. So I would caution against such notions. That is it from the defense. We would just affirm that, we believe that this would be improper and a violation of the rights of the appellant to have them sentenced to death. That is it from the appellant. Thank you very much for your time.
Thank you very much, Mrs. Montoya. I just realized that I was speaking at a whisper. We are going to deliberate and enter a recess for the same. If we determine that we will need to reserve ruling, then we will come out and let you know. But hopefully this won't take too long. Court's in recess.
All rise. Court's back in session.
All right, thank you everyone for your patience. In the interest of time and judicial economy, we have determined to provide a short verbal ruling today to be supplemented by a more extended written ruling after we have had the opportunity to deliberate about certain holdings. So the court finds, well, let's put it this way. The court first takes into consideration the relevant background and statutes. In this matter, Ms. Sparrow Winters was sentenced to death by Circuit Judge Montana Moss. An individual sentenced to death, if they are suffering from mental health issues, has 2 different pieces of legislation that are key to consideration, namely H.R. 138, which is known as the Capital Appeal Act. It was passed in 2022. As well as H.R. 272, the Psychiatric Holds Act of 2023. HR 138 identifies that only a single member of an appellate panel must determine that an execution should be stayed in order for that sentence to be overturned as a matter of sentence to death. HR 272 establishes that, as we've discussed in court, no defendant may be put to death if they are unfit to be executed, and that a defendant is unfit to be executed if, due to mental illness, they are rendered legally incompetent and or not of sound mind. Appropriate relief may be granted by the San Andreas Circuit and Supreme Courts. Before us today was an appeal of a sentence to death for Ms. Winters on the basis of her mental health, both through the findings of Dr. Helena Cassidy-Wren, as well as a report produced by Dr. Calicom, who is, as we all know, the preeminent expert of the Harper unit and a very well-known psychiatrist within the state. Having been presented the evidence and argument in court today, the court finds that Ms. Winters does satisfy the threshold of not being of sound mind and therefore is unfit to be executed. We will go into further detail in our written ruling explaining the basis for this opinion, but in the interest of proceeding with resentencing, we reverse and remand the death sentence of the circuit court for proceedings consistent with this opinion. We thank everyone for their time in court today, and court is adjourned with jurisdiction retained for ruling.